have just had some follow-up questions. That's what I understand of.
I actually had some questions, and I figured it's better we're all together.
Okay.
Hello.
Hi, Dave.
Oh,
Hi, how are you?
Dave.
I got Michael on the line.
Hi, everybody. I hear everybody.
All right. The questions I had, Dave, they were saying something about securing the mortgage with another mortgage or guaranteeing it with another.
What are you going to guarantee? What are you going to guarantee or secure it with?
Okay.
Hello?
So, can you hear me okay?
I can hear you just fine.
Okay, perfect. Okay, so go ahead and ask your question for me again.
Yeah,
My question is, if Mike's going to hold the mortgage, and you're going to put up some sort of collateral to secure that mortgage, what is it?
The collateral would be the house that Mike's selling.
The house subject to the contract?
So it would be, so the security agreement would be a mortgage, subject to the house. So it would be recorded onto the house. I'm not sure if I'm answering your question. I'm not sure if maybe I understand.
Somewhere in the contract, I couldn't make out what it meant. It said, because I asked Mr. Long, I said, how can you secure this? He said, is there any collateral or anything like that? And he said he could secure it with another mortgage. And I didn't understand what that meant. And then also he said something about transferring the properties that you had for collateral or something like that. And
it's generally what we would do. Here's the thing. I don't 100% comfortable with my client handing over his deed to you or, us holding the deed, however that's going to work out. So you could then derive whatever profit or whatever thing you're going to derive from the premises, and have you never pay Mr. Capuano a dime and then spend the next 3 years in a foreclosure court. I would much rather secure that note with something that's other and viable that might mean something more to you than the premises you just forgive me for saying this, but I'm just trying to make a point. The property you just stole from my client for $25,000 down payment.
Mm-hmm.
You know what I'm saying?
Mm-hmm. I hear what you're saying.
I'm not so comfortable with that. I recently did a deal on a house purchase where the seller held the mortgage and the purchaser put up 3 of his other properties as collateral on the note.
Okay.
So, because obviously my client didn't want the house back, but he held the note as collateral from a couple other viable properties in the area.
Certainly. So what you're asking for is some cross-collateralization.
Well, basically, because like I said, at the end of the day, you give my client $35,000, we do a closing, we hand you the deed, you don't pay him another dime.
Yep.
What are we doing? The way foreclosure courts are operating right now, it'll be 4 years before we step foot near that premises.
Okay. Would it be? Would you feel more comfortable, David, if we gave up our right to due process and just gave you the house back, and if we were 90 days behind?
The confession of judgment.
Yeah, I mean that's
so let's just.
That would certainly make me feel better.
If we can work more towards that solution.
If we can craft an agreement to that effect, I have no problem with that. Once you come 90 days in arrears, we get the house back.
I don't want to have you guys feel like you're going to be subject to consumer-friendly laws of a 3-year foreclosure process. That's not good for anyone. No, I want you to feel good about the transaction. We've never gone behind. We don't have any plans to go in default. We don't really want to try to cross-collateralize the properties that we also have in our portfolio. We just really try to be one property, one investor, one property, one seller. It just makes it cleaner. It's a little bit more complicated when we add additional properties to the mix, but I'd be happy to.
Understood, but you recognize my hesitation to do that just based on the fact that you swoop in for 25 G's and you work the property for 3 years and disappear.
Yep, certainly.
Stranger things have happened.
Yeah, yep. Oh yeah, of course, and all over the.
So if you want to draft some kind of the security note being the waiver of due process, and I don't know, maybe something other with the deed than filing it, maybe hold it in escrow somewhere with you Until we're full. How long are you looking to hold the note for? Us to hold the note for?
I can't remember. The initial offer was, Michael, do you remember the initial? I know the initial offer was probably, our standard initial offer is 15 years. I don't remember exactly.
I think it was 15 years. I think it was 15 years. I'm not quite sure when he upped the down payment to 25. I didn't really look at it quickly to see that how many years.
What was the sale price?
What was my sale price? 201.
With the 25 down, it winds up being 201.
Yeah, 201.
So we'd be holding it around 176.
Yeah. Well, yeah, exactly. Yep.
And there's a balloon also, right?
Yeah.
There's a balloon on that also?
Yeah, and that would be in that 15-year time frame. I'm just pulling up the other notes.
Did we discuss a negotiated interest rate?
It's included.
At what percent?
Typically we just use the federal funds rate. So
yeah, that's how it comes up to 101. That's included in there. That's what I would get back on 15 years.
So I just want to be accurate. Okay, so 201, yeah, it is 180 payments. 201 is the offer, 25 down. The balloon is 126.
And when is that paid, the balloon?
The balloon would be paid after 180 months.
Oh, so at the very end, the balloon is?
That's right, yep.
Like 15 years?
That's right.
All right, well, but in other words, it sort of couldn't be that balloon to get the house back.
I'm sorry, I got the math wrong. So it offers 201, cash down to 25,000, 180 payments of $700 a month, totaling 126,000. So that balloon is 50,000 at the end of 180 months.
Yeah, that's what that's the math I did real quick. Listen, I think fair enough. I mean, I feel a lot better with, the language in there that there's an immediate forfeiture. Due process is waived upon 90-day default.
Yeah, okay.
At least that builds in some kind of protection for my client. It's just my only problem is we'll have to see what we want to do with the deed.
Yeah, right. Agreed. I'll think about that. I'll talk to Jimmy about that, my other partner.
Yeah.
I'm not sure if you had a chance to talk to him yet, Dave, but I'll just chat with him.
I haven't talked to anybody. I'm just talking to you for the first time.
Okay. So I'll just talk with him, see what we feel comfortable with, and then maybe we'd have how this could pan out would be I'm not sure what the vehicle that we would use, maybe an option with a quick claim deed and escrow. So we probably want the deed initially, but then we could hold the quick claim deed and escrow in case of default. And so that in case of default, contract might take the form of an option, or it might take the form of something else, maybe a performance mortgage or something else. I'm not sure what vehicle we'd use or what document we'd use.
All right.
You may be.
I'm comfortable under that framework. If you want to draw it up.
Okay. That sounds good. I'll add that to the purchase agreement, and then I'll send it back over to Michael and he'll.
All right, Michael. Once you get it, we'll sit down and go through the whole thing.
All right. Very good.
Any other questions?
All right, Michael.
Yeah, no, that's fine. If my attorney's comfortable with it, I'm comfortable with it. Simple as that. So
excellent. Okay. Well, thanks very much for your time, Dave.
All right. So once we get that paperwork, we'll be in touch.
Yeah, Michael.